I call this meeting to order. Okay, Mr. Dhaliwal, but I have to give my ruling first, and then I will come to you. Where we left in the last week, so I have to give my ruling, and then I'll acknowledge you. I call this meeting to order. Welcome to meeting number 64 of the House of Commons Standing Committee on Citizenship and Immigration. Today, pursuant to the order of reference of Wednesday, November 16, 2022, the committee will resume consideration of Bill S-245, an act to amend the Citizenship Act, granting citizenship to certain Canadians. Before proceeding any further, I will return to the matter which was raised by Mr. Kimmich during the committee's last meeting on Wednesday, May 3rd. He described a situation in which a member of the public appears to have gained detailed knowledge of the package of potential amendments to Bill S-245, which was distributed to the members of the committee and was understood to be confidential. He suggested that this matter relates to parliamentary privilege and asked the chair, in accordance with the usual practice for matters of privilege in committees, to decide whether the matter indeed relates to privilege. Several other members have spoken to this. I asked the committee to allow me to consider the matter further with the understanding so that we can get back to the matters today. So thank you for giving me the time on last meeting. I would like to inform, based on the procedure and the rules, I would just like to inform the matter that members of the committee that the matter at hand pertains to potential amendments and some amendments to a bill that are understood to be confidential once they are distributed to the committee and until they are moved in the committee. Based on what the committee heard on Wednesday, May 3rd, it appears that such confidential information may have been shared with the members of the public. As such, I agree with Mr. Kimmich that matter he raised indeed relates to parliamentary privilege. So that's my ruling on that. And with that, I have a speaking list: Mr. Dhaliwal, Ms. Kwan, and Mr. Reddycop. So, Mr. Dhaliwal.
Thank you, Madam Chair. Madam Chair, pursuing on the same grounds as you mentioned about Mr. Kimmich. Mr. Kimmich raised a matter last week that we should all take very seriously, and is of course concerned to all the members here. That's why on Thursday I put a notice of motion. I move that pursuant to Standing Order 108(2), the committee invite Randall Emery to appear on the current study of Bill S-245, an act to amend the Citizenship Act, granting citizenship to certain Canadians. Madam Chair, it is very important to hear from the witness so as he can provide us with more information and context on this matter before the committee. Hearing from the witness first will help better inform the drafting of the report, and I hope all my colleagues on both sides will be able to support this and understand the intent. And perhaps it's a misunderstanding, but we won't know until we get the witness in front of this committee. So, Madam Chair, with this, I would ask the support from my honourable colleagues on both sides.
Point of order.
Gardner.
On a point of order, Chair, I'm just wondering procedurally, typically, my understanding is when a breach of privilege has been found, as you've just ruled, typically the order of business that happens in committee is that a motion would then be moved to remedy the privilege, the breach of privilege. So I'm just not sure if the order is appropriate. That said, I don't think that my colleague will find any argument with his particular motion. I'm just wondering if perhaps the better approach is for the motion regarding privilege to be moved, and perhaps we could include his request therein.
Thank you, Ms. Rempel-Gardner. I have given my decision, and now, as a committee, we have to go to the next steps. So, Mr. Dhaliwal has moved a motion, which also relates to the ruling I have given, that it relates to the privilege. I, as the chair of the committee, do not have the power to make a decision, but I have given my ruling. So we have a motion before the committee, and let's deal with it, and then we will go to the next steps. Any debate? Yes, Mr. Dhaliwal.
Thank you. If there is no other debate, I would certainly would.
It's like if I have a speaking list, I have Ms. Kwan. Ms. Kwan.
Well, thank you very much, Madam Chair. Speaking first to the motion, and I think first, before I get into that, I want to touch on the issue on your decision. On your decision, what you found is that the matter that's been raised relates to a matter of privilege. However, it is my understanding that, Madam Chair, you have not found that privilege has been violated at this committee. So I just want to make sure that's the case. And with respect to the motion from Mr. Dhaliwal, I certainly support the motion in calling the witness to come before the committee to provide clarity on the question of privilege. So to be sure, the witness, if that motion passes, the motion is to call him to come and speak before the committee on the question around privilege, and not to revisit, I assume, the issue around S245. Assuming that is correct, if I'm incorrect, I would like to have some clarity on it. I do think that that's an important motion from this perspective. I had the chance to go back and review the Hansard from Mr. Kamich on that was made at the last committee meeting. And he seemed to have indicated that he believed a breach of privilege of the committee has occurred. And I quote, he said, "What I've heard about the Liberal NDP compromise is that they will offer sub-amendments," end quote. And then he went on to say, that have just happened, quote, "to the NDP amendments to increase the connections test to 1095 days. The sub-amendment made the reference back to the substantial connections test only for parents." And that's also in quote. "We just remove grandparents," and then in quotes again, "and by right versus grant." And in his comment, that appears to be outlining the process of how things have occurred. And certainly that is how, in my engagement with my stakeholder groups, I had advised them that the NDP intends to move amendments to address the connections test issue, and that there are a number of areas that I would like to pursue. However, there was only agreement to move forward on the 1095 days and the parents and not the grandparents. So all the stakeholder groups certainly did know that, and that was something that I have informed them all the way through, and most certainly stakeholder groups were advised. It is my view, Madam Chair, that it's highly likely that the individual may well have, well, actually, I'm assuming that this is a very sophisticated individual who actually talked to every single party, in all likelihood, and got information on what their intentions were. My intentions had been open and on the public record from day one in terms of what I would like to do to amend S245 and to bring forward amendments that are indeed out of scope to address the Lost Canadian issue once and for all. Negotiations and discussions with the government side was something that I had started even before this year to see whether or not we can find a way to move forward on that. So these discussions had gone underway. And when it was clear that the government wasn't going to move on some of the items that I would like to see and go forward, I, in fact, did inform the stakeholder groups that I was connected with to let them know and to ascertain whether or not this is something that we would still want to proceed. And so that's clear as day. So it is entirely plausible that the witness or the individual in question may well have talked to a variety of people, gotten this information, and be able to piece together what the procedure is. And so to me, that is not surprising at all, nor does it actually show that privilege has been breached. What we're talking about here for privilege to have been breached is for the documents to have been shared. And I can assure this committee once again, as I did the last committee, that the documents that the clerk had sent to committee members was not shared by my office at any time, not by me or by my office at any time. And so I don't mind bringing this individual forward. What I am concerned about, though, Madam Speaker, is this. I feel like that this is a tactic that's being exercised to as an attempt to distract from the work that we're doing and to delay the work that we're doing. We're under a tight timeline, as all members know, that we have to report back out on this work to the House, and we have a 30-day limit set from previous committee meetings by way of that extension. And it's no surprise here that I know that some people at this committee meeting would not want to see the out of scope amendments dealt with. I am not, I'm disappointed about that because that certainly seems to be a change of position. But that said, that's what they want to do. And I think efforts are being made to prevent these amendments or prevent us in being able to report back to the House in a timely fashion. That's my greatest concern, Madam Chair. And getting to the bottom of this issue, I think what would be required is for documentations to be provided to prove that, in fact, a breach has occurred, to which I do not believe that it has. And so, Madam Chair, what I would also like for committee members to receive is the email that Mr. Kimich had provided to you at the last meeting. I had requested that from the clerk, and I was advised that it was handed to you, Madam Chair, as a casual act, as opposed to it being tabled as a document. And however, what I saw and what I thought I saw at the committee was for the document to have been tabled. But that seems to be not the case. I think that it would be appropriate for that document to be shared to all committee members so that we can see exactly what the suggestions in full may be. Madam Chair, I don't know if that is required by way of a motion for that document to be shared by the clerk to all committee members. If it is, I'll be happy to move that at the appropriate time. Thank you, Madam Chair.
Thank you, Ms. Kwan. Before I go to Mr. Redekop, just some answers to a few things which Ms. Kwan has raised. First of all, you mentioned when you started that in regards to the ruling I have given, just to make it clear to all the members of the committee, I will read a paragraph from page 1060 of the House of Common Procedures and Practice, 3rd edition, so that everyone is clear that what power I have and what I can do and what I do not have. The chair of a committee does not have the power to rule on questions of privilege. Only the speaker has that power. If a member wishes to raise a question of privilege during a committee meeting or an incident arises in connection with the committee's proceedings that may constitute a breach of privilege, the committee chair allows the members to explain the situation. The chair then determines whether the question raised in fact relates to parliamentary privilege. So that's what I did, and that's what the power I have. So just wanted to read that paragraph before so that everyone is clear. In regards, you have raised another issue in regards to the email which Mr. Kimich handed over to me. Mr. Kimich did not table that email in the committee proceedings, so that's why it was not circulated to all the members. He just handed that to me. If any document has to be circulated to all the members of the committee, then it has to be tabled. So that's why the clerk has not circulated that email to all the members. So these were some of your questions. And next on the list is Mr. Reddycop.
Thank you, Madam Chair. Appreciate your ruling. And, as far as the motion that's on the table, I think it makes sense that we would hear from him. I just want to address quickly, Ms. Kwan mentioned tactic. This is a tactic, I think she's implying to stall or something like that. This is not a tactic. This is a very serious potential breach of parliamentary practice and privilege. And so it's something that, regardless of what committee it happened on, this is a very significant issue. It's also precedent setting, and I think we need to deal with it accordingly. So it doesn't matter, what issue is before us today. I think it's incumbent on us as MPs to stop and deal with this issue. So I just wanted to make sure that was on the table. I would like to propose an amendment to this motion, and that is the following. After what has been proposed by Mr. Dhaliwal, we would add the following, comma, following which the committee report to the House of Commons the potential breach of privilege resulting from the premature distribution of notices of amendments to Bill S-245, an act to amend the Citizenship Act, bracket, granting citizenship to certain Canadians, close bracket, comma, to a member of the public before clause-by-clause consideration and amendments and sub-amendments were moved at committee. I believe the clerk has sort of this wording, not with Mr. Dhaliwal's piece, but with this piece. So that can be sent around. Essentially, what we're doing is saying, yeah, let's do Mr. Emery. Let's bring him to committee. Let's talk to him, and then following that, we will write a report and report this to the House. That's essentially what my motion is saying.
Thank you. Just 1 second. Let me recognize I have Mr. Brunel Dissep on the list, but just before that, I just wanted to check with the clerk if he has received the text. Okay, so he will circulate this amendment to all the members. Mr. Brunel Dissep and then Ms. Kwan.
So my question was whether we were going to be receiving the document in French.
Yeah, the clerk will get that document circulated. Ms. Kwan.
Thank you. And I didn't hear a clarification from you, Madam Chair, on the appearance of Randall is Randall Emery, right? Not Emery Randall. Randall Emery, for him to come before committee to address the question of privilege only. Am I correct to understand that?
So the motion which Mr. Dhaliwal had put on notice and with the motion which he has moved says that pursuant to Standing Order 1082, the committee invite Randall Emery to appear on the current study of Bill S-245, an act to amend the Citizenship Act, granting citizenship to certain Canadians. That's the motion which Mr. Dhaliwal has moved and Mr. Reddycop has moved an amendment. So now we have an amendment on the floor. So we have to deal with the amendment and then proceed to the main motion. Thank you. Mr. Reddycop, I'll come to you. Okay.
So just briefly before we proceed, I just want to clarify. So you will have received an email, and it has my piece of it. So if you just add, if you delete the word "that" and add the word "following which," that would then be my amendment. That you should have seen that email.
Chair, I think I want to thank Mr. Reddycop for bringing this forward. But as I spoke earlier, I mentioned that the report is going to go to the Parliament anyway. So this witness will help. So the intent was there.
Thank you, Mr. Dhaliwal. The clerk is working and getting it circulated to all both languages. Okay, so the clerk has circulated the amendment moved by Mr. Reddycop in both languages to all the members. Mr. Kayabaga.
Thank you, Madam Chair. Could we just suspend for a minute just to sort of look over their amendment and then get back to you?
Minutes, yeah.
Yeah, like just 2 minutes.
5 minutes.
If the members would like to go over. I will suspend the meeting so that members can have a look at the amendment moved by Mr. Redekop. The meeting is suspended.
Go talk to them.
Order. We have the amendment which has been proposed by Mr. Redekop on the floor. Ms. Kayabaga.
Thank you, Madam Chair. I just want to put on the record that I think that the purpose of this motion is to hear the witness before the committee to make the decision. And I think that we would like to keep the two motions separate. So we will vote down the amendment, and then they can move the motion if they like.
Any further discussion? Seeing no further discussion. Mr. Redekop.
I guess I have a question. If this gets voted down, no? Okay. No, that's fine.
Okay, so if we can please take a vote on the amendment proposed by Mr. Redekop. Mr. Clerk, if you can please take the vote.
Mr. Ali.
Against?
Mr. Dhaliwal. Mr. El Khoury.
Against?
Madame Kayabaga.
Contre.
Mr. Maloney.
Against?
Mr. Redekop.
For.
Mr. McGuire.
For.
Ms. Rumpel-Garner.
For.
Mr. Jenis.
For.
Ms. Sabrina Duceppe.
Pour.
For.
Ms. Kwan.
Against?
Yeas 5, nays 6.
So the amendment sub-amendment proposed by Mr. Redekop is defeated. So we have back to the motion moved by Mr. Dhaliwal. Mr. Redekop.
Madam Chair, I have another amendment. I would like to add at the end of this, at the next meeting. I think it's important that we get him here as soon as possible.
Sorry, can you please repeat what amendment you are moving?
At the end of the motion, just add the words "at the next meeting."
Invite Mr. Okay. So Mr. Redekop has moved an amendment to the motion proposed by Mr. Dhaliwal. Ms. Rumpel-Garner.
I think this amendment, if what my colleague is doing, it states something that procedurally would have to happen anyways. My understanding is because this is related to the matter of privilege, the appearance of this person. Otherwise, Mr. Dhaliwal's motion would not have been ruled in order because it's very uncommon for motions to be moved during a clause-by-clause reading. But because it's a matter of privilege, it takes precedence. So my assumption is because the appearance of the witness is related to the matter of privilege, it would we can't move forward on clause-by-clause, which we want to do, until he appears and privilege is disposed of. So I think what I'm saying to colleagues is the amendment states the obvious, and I support it for that reason.
Ms. Rumpel-Garner, in regards to the motion which has been moved by Mr. Dhaliwal relates to the issue which we have and the issue on which I have given my ruling, so that's why we are dealing with it. But in regards to, if we finish and vote on this motion today, we can deal with the clause by clause and invite him, like the individual, in the next meeting. But in today, that's what I've been advised by the clerk, that if we have to deal by clause, we can deal clause by clause after we are done with this motion. Yeah, that's what I just wanted to clarify. Mr. Dhaliwal.
Madam Chair, you already clarified because off record I was talking to one of my friends on the other side that this is an important bill and the amendments are made. Let me do the clause by clause because we should not interrupt the movement of the bill because, Senator Martin has brought this forward and so much work has been done. So you have already given the ruling, so we should proceed with the clause by clause. But at the same time, we should bring the witness ASAP.
Again, just to put on the record, though, for my colleagues opposite, the point of my colleague's amendment, I believe, was to the original motion was to try and codify what we just said, right? Was like, let's get this all disposed with so that we can expedite the cause by cause of the bill. But unfortunately, because it was voted against, we are now going to have to vote a separate motion and dispose of that motion ahead of this. So what we were trying to do was do what Mr. Dhaliwal said, but because they voted it down, now we have to address everything separately, which creates more blockages. So I just want to put on the record that what we were trying to do was actually give more time, just for the record, and be expeditious. But here we are. So.
Trample Gardner, Mr. McGuire.
Yes, my understanding from the last meeting we had was that, and I appreciate your ruling, Madam Chair, but then I felt that from that the procedure was that we would not be able to proceed until the witness had actually appeared here before us, and of course without any knowledge of your ruling or the witnesses, being notified, which we couldn't do until now, that we wouldn't be able to proceed today at all. And so I think the amendments that have been brought in maybe clarify that a little bit, but I was concerned that, and I understand from what you just said that you've got a ruling that indicates that we can proceed. I wonder if you could just clarify that.
Mr. Janice.
Yeah, Madam Chair, first of all, good to be back at this committee. I'm sorry that it's under some less than ideal circumstances, given that we're talking about a privilege issue. I was just going to say that what parliamentary privilege is the privileges that allow members of Parliament to do their jobs. So if there's been a violation of privilege, then that violation of privilege is impeding members' ability to do their jobs, and that's what we're considering in the context of this privilege debate. So it would seem odd to me to go on with the item of business in which the violation of privilege occurred and put aside the privilege violation, because that violation of privilege materially impacted or could have materially impacted the proceedings that were happening. That's why it's a breach of privilege, right? If it is a breach of privilege, then it matters to the considerations underway, and if it matters to the considerations underway, then you have to deal with the privilege issue. You can't just revert back to the considerations underway as if nothing had happened. That said, I think we're probably all agreeing on this amendment. I just wanted to make the broader point in the context of the discussion. So you support the amendment to have the witness come right away, but the point is, based on your ruling, it seems to me that it's a given that there has been an impact, or there could have been an impact, on the clause-by-clause proceedings, and that means we do have to attend to the privilege issue as a priority, because that will help us contextualize other steps that the committee needs to take on the issue from which the privilege point arose.
Thank you. So I just for colleagues, I'd like to explain, the reason why a motion related to privilege supersedes the course of proceedings for clause by clause is because the point of privilege relates to the clause by clause study. Okay? So because the finding of privilege relates to the clause by clause study, we have to dispose of that before we move forward with the clause by clause study because it actually impacts the proceedings on the clause by clause. Otherwise, it wouldn't proceed this. So procedurally, we have to dispose of this and dispose of it quickly. And I want to point out that procedural matter for my colleagues. That's all. It's just we have to dispose of this so we can go on to that. And our intention is to do that quickly, but we have to understand what happened here because it materially impacts how we're reviewing those amendments.
You, Ms. Rempel-Garner. Next, I have Ms. Kwan and then Mr. Dhaliwal. Ms. Kwan.
Thank you very much, Madam Speaker, Madam Chair. Just want to be very clear to say that your ruling indicated that the question that was raised is related to a matter of privilege. However, that there has been no ruling made that violation of privilege has been found. In fact, you made no such ruling. And so to that end, the motion that was passed, moved by Mr. Dhaliwal, was to invite the witness who may have some information related to this, as he was cited in the email that was provided by Mr. Kamich that indicated that the question of privilege is being raised. And so for him to come before committee as soon as possible to answer questions related to the question of privilege, I think is a wise thing to do and a valid thing to do. That said, where we are at today is that it has not been established that there's been a violation of privilege. In fact, I don't think that there has been one. And I think that is quite possible that the information provided in citing the witness, Mr. Randall Emery, may well have been able to gather information from a variety of sources and put it all together to make it seem like maybe he received the amendment package outside of those of us who received it from the clerk. And so to that end, getting clarity on that would be useful, I think. However, I just want to reiterate the point that there has been no establishment of violation of privilege being made at this committee, nor do I necessarily believe that all committee members think that a violation of privilege has been established.
Thank you, Ms. Kwan. Just want to clarify that as chair, I have no power to make that assumption. So what we can do is report. So we are in that process in regards to what was raised by Mr. Kamich. So this motion which has been moved by Mr. Dhaliwal relates to that. That's why we are dealing with that motion. I have next Mr. Dhaliwal and then Mr. Janice. Mr. Dhaliwal.
We are just going off the motion. I thought we were only working on the motion, but when it comes to clause by clause and all this, first thing first, it's not only you that can make a decision on the privilege, not make the decision on the privilege. In fact, the committee cannot make this decision either. Committee can only send a report. Speaker is the one that makes the decision. And when it goes to the speaker, then the privilege takes the president over everything else. But in a committee, we can continuously, start and continue to work on different things that we need to do. So I think we should focus only on the motion right now, and then we can go to other stuff like clause by clause and whatnot. So that should be a separate issue. Let's finish the voting on this motion, and then we go from there on.
Mr. Dhaliwal, yes, we have a motion and we have to deal with that before we proceed any further. I have a speaking list. Once we have exhausted the speaking list, then we will vote on the sub-amendment which has been moved by Mr. Reddycop, and then on the main motion as amended or not. So next I have on the list is Mr. Janice and then Ms. Rempel-Garner.
Yeah, thank you, Madam Chair. I was just going to respond to a couple of the comments that were made. So, Ms. Kwan is right that the chair has not ruled on the question of privilege, but that's simply a description of the appropriate, it's a correct description of the jurisdiction of the chair. The chair does not rule on questions of privilege. The chair has made a ruling that is in effect as far as the chair can go in acknowledging the seriousness of this matter and its relationship to privilege. And so what is appropriate then is for the committee to forward the issue in a timely manner onward for that further adjudication and determination. But I think that needs to happen quickly, and it shouldn't be. The committee needs to proceed in a way that accords with a recognition of the seriousness of the issue, and that means, as the amendment says, having the hearing from witnesses right away, and as we're going to propose, it means preparing that report and allowing the committee to move on. But the issue is, I think, that one can't simply go back to the issue from which the privilege question arose. It's legitimate for a member to have the opinion that actually there wasn't a violation of privilege. That's an opinion. It's an opinion I disagree with, but it's an opinion. But the point is that given the recognition of the seriousness of this, we can't go back to that item based on the until the matter is considered and resolved, and that's why it's important to, I think, first consider the witness. Well, adopt the motions we need to adopt today to hear from the witness, to proceed with that report, and then to allow that ruling to happen. So this is the flow that needs to take place. And again, it's an intricate piece when you come to privilege questions, but everybody has a role to play. The speaker would make a finding, a prima facie case, but even then, that then refers it to a committee if the speaker makes that finding. So all these are steps in the process, and so I think just making that happen quickly in the proper order is what we're saying needs to happen. So, thank you.
Mr. Janice, just to clarify for all the members that Mr. Dhaliwal's motion has not passed as yet. We had an amendment which was voted down, a sub-amendment. Now we have another sub-amendment, and that's what we are debating on. Mr. Ampel-Garner, and then Mr. Reddycop.
Thank you, Chair. Okay, so on Mr. Reddycop's motion about having the proposed witness by Mr. Dhaliwal attend the committee at the next meeting and why this is important. So where we're at right now, and I again, this is not partisan, this is just my perspective as a legislator. So where we're at right now in the review of this bill is that we are now considering amendments that are allowable because of a special motion in the House of Commons, which allows this committee to consider amendments that were far beyond the original scope of the bill. Okay, that went through the House of Commons. These amendments are highly technical. They affect the scope in which citizenship can be conferred to people. And, to date, the tone of debate on these amendments with officials have been, asking a lot of questions about impact. So these amendments that have been brought forward, they weren't shared with all members of the committee to start with. And we have been trying to do diligence step by step with the officials to understand their impact. Also understanding at the heart of this bill, there is broad consensus, but the amendments are broad. So my concern as a legislator and why privilege has to be dealt with first is because if somebody outside of the committee, as the chair has noted, received these amendments in such a way that wasn't in accordance with rules, and we haven't, and we're trying to dispose of this, it raises questions about the impact of the amendments, the scope of the amendments, the intention of the amendments, and whatnot, right? That's why privilege exists. It's not a gotcha moment. It's a safeguard to ensure that the legislative process is followed appropriately. So Mr. Daluwal, I'm assuming, is asking this person to come to committee to understand what happened, okay? And I would like to know as well. But we can't go forward and continue to look at amendments that might be impacted by a potential breach of privilege, right? So I think that's what my colleagues are saying here. So I want to just, for my colleagues, and if they want to follow along, in everybody's favorite green book, here's a plug for it, bestseller on Amazon.ca, on page 154, it deals with this issue. So it goes through, just to clarify, I want to sort of summarize everything that's happened to date. So it starts off with outlining the scope of what the chair can't do, so can and can't do. Unlike the speaker, the chair of a committee does not have the power to censure disorder or decide questions of privilege. Should a member wish to raise a question of privilege in committee, should some event occur in committee which appears to be a breach or contempt of privilege or contempt, the chair of the committee will recognize the member and hear the question of privilege, which is what our chair did with Mr. Kamek last week, okay? So that's step one. And again, this relates to the sharing of confidential amendments outside of the committee during the clause by clause. So it goes on to say the role of the chair in such instances is to determine whether the matter raised does in fact touch on privilege and is not a point of order, a grievance, or a matter of the debate. If the chair is of the opinion that the member's interjection deals with a point of order, grievance, or a matter of debate, or that the incident is within the powers of the committee to deal with, the chair will rule accordingly, giving reasons. Okay? So what I believe the chair has done here, and my understanding, is that the chair has said that this matter does in fact touch on privilege. Okay? So that's what has happened today. It says the committee cannot, should a member, committee can sustain or overturn if, in the opinion of the chair, the issue relates to privilege, then the committee can proceed to the consideration of a report to the matter on the House. Now, I'm assuming that my colleague is inviting this fellow in the motion because it is of substance to our determination on this issue. But Chair, and to my colleagues, because the matter of privilege that is being considered potentially touches on the clause-by-clause consideration of this bill, then we have to dispose of this. The committee has to decide whether or not it's privilege before we move on. Okay? That would be my interpretation here. So I think we can dispose of this quickly. Okay? I really do. But that is why my colleague is calling for this. So let's get this person here. Let's question him. Let's dispose of the issue. And that's where, my colleague, Ms. Kwan, has a difference of opinion on what happened, whatever. But because the chair has ruled, as she did today, it is now our responsibility to deal with this as the first matter in front of our committee. And this is one of those moments where, from time to time in committees, you'll see members of all political stripe, using procedural tactics for one thing or another. But in this instance, that's not the case. This is a matter that materially impacts how this committee, we're legislators, we're making laws, and I'm giving this really impassioned, nonpartisan speech, but we have to consider whether or not privilege was broken because it has an impact on how we are debating amendments. And these are the sort of things that lawyers look at down the road. We should make sure that in all of our deliberations of law that we are, and the legislative process, that we are adhering to procedure so that we are respecting the structural integrity of how Parliament functions and works. So I ask my colleagues to play it by the book on this one. I really do. Let's get this guy here, let's dispose of it, and then let's move on to clause by clause review. I think that's reasonable. I think that would give everybody, regardless of how they feel about this issue, some comfort that we're, handling this matter with appropriateness and transparency. And And that would be my preference. So yes to my colleague Mr. Radikopp's motion, and we have to dispose of this. Thank you, colleagues.
Thank you. Next on the list is Mr. Reddycop and then Mr. Maloney. Mr. Reddycop.
Thank you, Madam Chair. So my colleague, Ms. Rumpel-Garner, and also Mr. Genius were talking about timeliness, essentially. And of course, that's the basis of what I'm talking about in my amendment. And I just want to reiterate that this is a very, just what my colleague was just speaking about, it's a very important, pertinent issue that we need to deal with as quickly as possible. And I'm just concerned that the way the motion is written, it doesn't convey that. In fact, it doesn't even mention this issue. It mentions S-245. So that's my concern, is why we need to do something to put a little bit more teeth, I suppose, if you will, into this motion, so that we make sure that it's done on a timely manner and as quickly as possible. And this next meeting would be the one to do it at. For all the reasons that have been stated already, we do need to deal with this first, or as quickly as we possibly can, because it does affect what we do potentially in some of the deliberations. We've had a lot of very good questions. We unfortunately didn't get a chance to discuss a lot of the NDP motions with the NDP, and so that's partly why we ask a lot of questions of our department officials who are here and probably bored out of their minds at the moment right now. But we appreciate you guys being here and the answers that you've given so far, and it's important that we ask those questions of the bill. But we also have to be careful that we're not there isn't improper influences happening to us as well. I mean, we've all had different people contacting us about this bill, and it's one thing if somebody has an opinion and they share it with us or with our office, but if that person has actually been privy to very detailed information about amendments and things like that, that can change things, and it can impact in an unfavorable way what we choose to do potentially. And so I know that there's particular stakeholders that have been phoning us repeatedly and sometimes multiple times a day, and that's not necessarily helpful for us. And so some of those things can be wrongly influenced, I think, by somebody having information that they shouldn't have. And so that's kind of the core issue as you get back to the privilege that we're speaking of today. And that's why I think it really is important that we put a time condition onto this, so that we are not, we don't end up at the end of June and all of a sudden find out that we haven't got a chance to get the witness here. And so that's why I want to see us have some kind of a time limit on here, so that we get this done very, very quickly. And my preference would be to do it right away this week, and then we can dispose of it, and as we said, move on to the substance of the bill and get it back, because as we all know, there's a deadline of that, which I believe is June 15th, to get it done. So we still have some time, and that's a good thing, but we need to get that done. So that's the timeliness factor, and why that needs to be done quickly. I also just want to address the issue or the question, I suppose, of has there been a breach? And I think, Madam Chair, you rightly stated that you're not the arbiter of that. You do not decide if there has been a breach, but you decide if there's been enough evidence, to support the investigation into that. And that's what you've done, and that's good. But there was some mention from Ms. Kwan about this document that was not tabled, and that was the choice of the person who had the document. From what I understand, and that was what was in that document, and I think Ms. Kwan alluded to some of this, there were very specific references in there to specific amendment numbers. And so even if somebody generally understood that government amendments are typically G1, G2, G3, and so on, even if they understood that basic concept, they would have no way of knowing that, G3, for example, was specific about this versus G5 about that. They wouldn't know that. So, having that level of information, which is what I recall seeing in that document, that's very specific, and that is, to me, very indicative of a potential breach. Somebody somehow passed that information on to them, and that's why I think it's important that this gets reviewed in more detail. And the other thing that was in that document, as I recall, was a bit of strategy, actually, that, you know, A is going to happen and then B will happen. You know, there'll be a motion for this and an amendment for that, and, you know, kind of a bit of a plan, if you will, that had been created and devised, and that was essentially what was in this document, which when it was received seemed a little bit interesting, and then lo and behold, when we had our last meeting, that plan that was outlined in that document is in fact exactly what happened. And so clearly this person not only had access to information they shouldn't have had, but they actually had the access to the strategy, if you will, that was going to be used by the person moving that. And I'm not sure that necessarily is part of a breach. I don't know. That's what we'll have to study, because that part I'm not exactly clear about. But certainly having some of that information, I believe, was clearly a breach of privilege. And as was said before, we around this table certainly reserve the right to agree or disagree with whether it is a breach at this point, because we haven't had the full disclosure. But I also believe that's why it's so important to have this witness come, because they're the ones who know. They know the answers to these questions, and I think every one of us needs the opportunity to ask these questions, to find out the truth about where it came from. And it's not so much about punishing somebody necessarily, because, you know, there could be legitimate faults in the way that some members run their offices, and I don't mean that in a critical way. It could be actually a legitimate hole that needs to be plugged, if you will. And that's whenever, you know, I love aviation. And so I often watch, and some of you may have watched the shows, you know, there was a plane crash and they describe all the things that happened that led up to that plane crash. And often there's multiple things. And it's not about assigning blame so much as it is to figure out what went wrong and plug that hole so that the next time it doesn't happen. And so I think that's kind of the same principle here, that it's not so much about assigning blame to somebody, but it's about figuring out why it happened and what flaws, if you will, there were in the system, and then figure out a way to plug those holes, fix those flaws so that doesn't happen again. So it's really, I believe that's really important, and a really important outcome of this. So I think that's kind of summarizes some of my thoughts, I guess, for now. That and as I said, the main thing that I want to do is make sure that we have a timeliness associated with this, so that we don't end up just delaying this and not dealing with it. I think it's very important. So thank you.
Thank you, Mr. Reddycop, and just so that all members stay on that point, like we are debating the amendment which has been moved by Mr. Reddycop. I have two more people on the speaking list. Mr. Maloney, welcome to CIMM, Mr. Maloney. I hope you are enjoying the meeting.
I'm thoroughly enjoying this meeting. It's fascinating, and you are discussing a very point. Mr. Reddycop, you should watch the show Mayday if you're interested in aviation. That's the one you were talking about. Look, I agree with what Mr. Reddycop said insofar as this needs to be dealt with as quickly as possible, and from what I can gather from listening to people around the table, so does everybody else. I disagree that it has to be done now. The section from page 154, read by Ms. Rempel-Garner, taking the words literally, does not say that your ruling precludes this committee from proceeding with the clause by clause. In fact, my interpretation would be it says the exact opposite. What it says is that you can, once you have made your ruling, Madam Chair, we can then consider it going to the Speaker, which you have done. Procedurally, what we have to deal with right now is Mr. Reddycop's motion and Mr. Dollywall's motion, and that's where we are. Thank you.
Next, Mr. Janis, and then Ms. Rempel-Garner. Mr. Janis.
Thank you, Chair. So, respectfully disagreeing with the direction of Mr. Maloney's comment. So, just remember, there's a rule when there's a violation of privilege that you have to bring the matter at the earliest reasonable opportunity, and that's not precisely defined in the standing orders, but the spirit of it is that you can't feel your privilege is violated and go think about it for 2 weeks and then come back and move the issue. Because privilege is supposed to have an element of urgency to it, right? There's something happening that is impacting the ability of members of Parliament to do their job. And if it's really an issue of privilege, then it sort of naturally flows that there's an urgency from it. Just going back over my memory of the privilege issues we've dealt with, one issue was certain members that that were impeded in being able to come to the House for a vote because there were certain security protocols associated with. I think it was a foreign leader that was visiting, new security protocols. They were not able to get to the House to vote, and therefore there was a privilege issue raised because they were prevented from exercising the privilege, which is to vote. So the urgency of that matter is the fact that that people are being prevented from voting, and so it has to be dealt with right away because there are votes that are going on all the time, right? So if you put that issue off, you say, well, yeah, people are being prevented from voting, but we'll deal with it in 2 months. Then in the intervening time, you have the continuation of the problem, which is people being prevented from exercising their privilege. The House right now is debating a question of privilege involving foreign interference, and it's obviously an urgent matter because foreign interference didn't just happen once to one member at one point in time. It's an ongoing concern, and there are ongoing issues that have to be resolved as soon as possible, which is why not only members are required to bring it forward right away, but in the House on matters of privilege overrides everything. It is unlike everything else. It actually overrides even private members' business. And Speaker Reagan ruled previously that if the government adjourns debate on a matter of privilege, it comes back right away. So it has this unique character within our standing orders of the House necessarily being seized with it until it's dealt with. I think people understand that, but it's because of the urgency, because of the importance of the matter, and because of the importance of it being dealt with right away. So I don't know that the process for consideration of that matter is as formally structured in the rules at the committee level, but I think it's important for us to act with an appreciation of what privilege means and what the practices of the House can teach us in terms of our practices here at committee, which are that if the matter is urgent and if it necessarily overwrites the other things that are going on, that at committee we should say this is important, this is urgent, this is impacting the privileges of members. So it's particularly impacting the privileges of members in the context of clause-by-clause consideration of a particular bill. So we need to understand what happened and how it can be resolved if we're going to take seriously the resolution of that privilege matter. It has to happen in that sequence, and it has to happen in a way that I think acknowledges the operating principles that we get from the House, which are urgency, primacy, and the need for the privileges of members of Parliament to be protected in order for members to do their job. If I don't have my privilege protected, then I can't do my job, and I can't properly move things forward. And so, for this committee to function, again, that privilege needs to be respected, and that is a precondition for all of the things that have to happen next. So, I think the principle of the amendment is to say, yes, we need to hear from the witness right away because we need to get towards a resolution. Mr. Redekop has put forward an amendment, and I understand maybe it's going to come forward in a separate form that actually deals with the privilege issue, because actually the other issue I have in general with this motion, I mean, support it, great, like let's move it forward, but I don't see this motion as directly addressing the issue of privilege. It says we're going to hear from a witness that is going to help us enumerate some facts, but it doesn't actually lay out the process for resolving the privilege issue, and that's what we're supposed to be doing, right? Once the important issue of privilege has been determined, the committee, just as would happen in the House, the committee must then respond to the issue of privilege accordingly. So that's the right thing to do. That's consistent with the long-running practice and traditions of the House. And but it's not just the right thing to do because it's the traditional thing to do. It's the right thing to do because it's what protects the ability of our institutions to function on the matter that comes next. First, we establish that we've resolved whatever considerations or issues relate to the to the protection of the privileges of members. And then we can build on that secure foundation of privilege being respected and recognized to go on to the next step. So it seems to me that the sooner the committee is able to take those steps, the sooner the committee is able to go on to next steps. So I would just encourage that kind of prioritization, and I'll leave my comments there.
Janice, I have 4 people on the speaking list. I have Ms. Rempel-Garner. Ms. Rempel-Garner. Then Ms. Kwan.
I just wanted to respond to my colleague, Mr. Maloney, and walk through that line of thinking. So Mr. Maloney is right, through you, Chair, in that it's now the committee's job to determine whether or not this is a matter of privilege. And that's what we have to be dealt with, right? That's what we're dealing with right now. So why I think the witness needs to come right away is because I think that if he doesn't, I would raise another matter of privilege, and I want to walk you through my logic on that. What we're discussing here is that potentially, while a bill was in committee stage consideration and the potential amendments were in confidence, which is a very, that's actually like a sacred part of the legislative process, and there's rules around it, that these amendments were circulated to third parties without the knowledge or consent of the committee, and that there potentially could have been third-party input during that stage of committee review, which is highly problematic. I mean, I don't understand if there's lobbying concerns in here or what the issue was, but it's problematic, and there's rules around that process for a reason. So if we don't have this person here right away, let's game this out. Okay, let's game this out. Let's say we don't have this person come before the committee. We don't deal with we don't deal with the privilege issue. We don't dispose of it. And let's say we get through the amendments and we refer the bill back to the House. There are procedural questions, and I would argue, I would look for an interpretation, but I think potentially legal questions on the validity of that issue or of those amendments should we rule privilege later, right? So this is why, so to me, is if we don't have this person come at the next committee and we don't dispose of this, then to me, that's a breach of my privilege as well. So this is why this needs to be done right away. And again, going back to why we decided to put that whole motion together was let's deal with this at once so we can move on, right? So what I'm saying though is I'll just put what my concern is on the table, and perhaps my colleagues can allay my fears. I am concerned that if we don't have this person at the next committee, that they're never going to come, that we're going to get through all of these amendments and we don't dispose of this until after the bill has gone back to the House. And that's just partisans hats off for a second. Can you imagine colleagues on the other side, if we had done that and leaked it to a third party group, there would be hell to pay, and rightly so, right? Because there's a reason why we have these processes in place. So I would just say, look, we've been asking technical questions on very technical amendments that have been basically table dropped to us from colleagues. We are trying to get this through as quickly as possible, given that these, guys, these are really technical, big impact amendments to a significant piece. Honestly, the Citizenship Act is more complex than the Income Tax Act in some ways. I am trying to review this to weigh on the balance whether or not this is in the best interest of my community or not, which is what we are paid to do. We need to know if there was a breach of privilege. So I would be prepared to probably raise another point of privilege, I think, if we are not having this person come, dispose of the matter of privilege, and people can agree or disagree if there was, but we have to put it to bed for the sanctity of the process that we're working on right now. That is my 2 cents. So I would ask colleagues through you, Chair, is if the intent, I just want to know, do the Liberals intend, do they want him to come? Do they want him to come to the next meeting? Because if it's no, then they will vote against this, and that tells me that they do not want to deal with the matter of privilege. And that is highly problematic for me, not as a partisan, but as a legislator. And my colleagues opposite never want to be in this position where they are considering amendments to a substantive piece of legislation with a matter like this in front of them. It has impacts for our constituents. So if this is just like, we're not going to deal with this, like, why go through the charade, right? If you want to deal with it, through you, Chair, have this person at the committee the next time. If you don't want to deal with this and don't think that there is a matter of privilege, then let's deal with that too. But my sense is that my colleagues want to get to the bottom of this. And if that is in fact the case, let's accept my colleague's amendment, have this person at our next meeting, which I'm sure our lovely chair can schedule, because she always does that well. And then we can move on with life and hopefully get this bill through expeditiously. Thank you.
Mr. Rempel Garner, next is Ms. Kwan on the list. Ms. Kwan, you can please go ahead.
Thank you, Madam Chair. I don't have any trouble having the having the witness appear at the next committee meeting. There seems to be quite a lot of assumption that somehow that's not what people want. I would love for the guy to show up. In fact, I would love it if he actually show up today so we can get to the bottom of it. But that said, I don't have any trouble whatsoever for him to show up at the next committee meeting, Madam Chair. The other thing I just want to point out as well, it seems that this committee, there are always these questions of privilege. And there's a situation that I recollect in the past where the question of privilege was raised about an email that was sent that included perhaps government or minister officials. And I recall actually that instance, I had moved a motion to invite the law clerk to come to speak to committee, which took some time, by the way. And we did eventually have that come before committee. And we were able to sort of still carry on with the work that we needed to do while we waited for that information. Just saying.
Next, I have Mr. Brunel Desep. Mr. Brunel Desep.
Thank you, Chair. Well, Madam Chair, once again, I'm going to be the Quebec sovereigntist trying to mediate a solution between the Federalist parties. That might seem strange, but I think that's actually the situation we're in today. So I just wanted to point out to my colleagues that if we don't accept, well, I'm just trying to find a common sense solution here. If the witness doesn't come quickly, as the Conservatives are asking for, we are going to end up with a committee that just doesn't work. We're going to waste a lot more time that we could have saved by going forward. So I would suggest that my Liberal and NDP colleagues go along with the Conservatives' motion here. Let's ask the witness to appear, and then we can actually get back down to the actual substantive work that we have to do in committee. So we can deal with S-245. So your good sovereigntist friend here is trying to find a solution.
Brunel Desep, I appreciate that. So next I have two more people on the speaking list, Mr. Al-Khouri and then Mr. Dhaliwal. Mr. Al-Khouri. Okay, you.
Alexia is already.
Mr. Al-Khouri.
Yes, thank you, Madam Chair. I remove my role from speaking because it was done by my colleague. So you could give my turn to another colleague, please. Thank you.
Mr. Dhaliwal, you also don't want to speak? Okay. Seeing no further hands raised, so we can vote on the amendment proposed by Mr. Reddycop. Mr. Clerk, if you can please take the vote. So we, just to make it clear to all the members, we are voting on the amendment moved by Mr. Reddycop.
Mr. Ali. Yes. Mr. Dhaliwal. Yes. Monsieur El-Khouri.
Yes.
Madame Kayabaga. Mr. Maloney.
Yes.
Mr. McGuire.
Yes.
Mr. Reddycop.
Yes.
Ms. Rempel Garner.
Yes.
Mr. Janis.
Yes.
Mr. Brunel Duceppe.
Oui.
Ms. Kwan.
Yes.
Yeas 11, nays 0.
Okay, so the amendment moved by Mr. Redekop is adopted. So now we have motion as amended. The motion which was moved by Mr. Dhaliwal as amended. Mr. Redekop.
Thank you. Thank you for that, but I do have another tweak that I would like to make to this motion, and it has to do with the part that refers to S245, and we kind of talked about that a little bit, where we need, I believe we need to change it to word, so that we're referring to the potential breach of privilege rather than S245, just so that we don't have any problems with, we have to be careful of our motions, because privilege motions take precedence on this, and I want to make sure that that's done. So my amendment would be as follows. So the current words that say, where it says current study of, so the words current study of, and sorry, Alexi, that's on a Yep. So just the three words, current study of, and we replace that with the wording from my original motion, which is potential breach of privilege resulting from the premature distribution of notices of amendments to, and then it carries on, so that it would read as follows. I'll read the whole thing then. So that pursuant to Standing Order 108, bracket 2, the committee invite Randall Emery to appear on the potential breach of privilege resulting from the premature distribution of notices of amendments to Bill S-245, an act to amend the citizenship, granting citizenship to certain individuals, and then my previous amendment, which I think was by this Wednesday, or in the next meeting.
Okay, so I will request the clerk to please circulate this in both official languages to all the members of the committee. I will suspend the meeting for a few minutes so that everyone has that in both the official languages, and then we will proceed. So the meeting is suspended. I hope all the members have received the amendment moved by Mr. Reddycop in both the languages. So, Mr. Dhaliwal.
Thank you, Madam Chair. Madam Chair, first of all, I would love to thank my Quebecer friend Brunel de Sepp for his thoughtfulness. And I also would love to support Reddycop's motion as well. I think there are consensus in the room, so let's pass that and amendment and the main motion as amended. So carry on with the business.
Thank you, Mr. Dhaliwal. Seeing no further debate, Mr. Reddycop.
Thank you, Madam Chair. Yeah, so I appreciate
Sorry,
that.
Madam Chair, I have my hand up.
Yes, Ms. Kwan.
Thank you very much.
No, I have Mr. Reddycop and then you. Mr. Reddycop.
Oh, I see. Okay. Speaking to the motion or the amendment.
I guess just so that we're clear on this, this kind of relates also to the timing, just to make sure that we have it's clear that this is not about 245 per se. It's more about the privilege piece of this, and I think that's why this I think clarification needed to be made. And it's also good for the witness to understand why they're coming to committee in order to be clear that it's not so much about 245 as it is about this potential issue of privilege, so that he's aware too of why the committee is calling him. And I think that's important to be fair to him, so that when he comes here, he's not blindsided by questions he wasn't expecting. So I guess that's the reason I'm trying to clarify this, and I think it's important that we are clear on this, because it as has been said by others, it is a very significant issue, and we need to get the best testimony that we can here, so that depending on where it goes past this committee, we have good information for those who will look at it afterwards and be able to determine and make assessments in terms of where this is going.
Thank you, Mr. Reddycop. Next, I have Ms. Kwan. Ms. Kwan.
Thank you very much, Madam Chair. Just on the language of the motion, I want to be sure that when it refers to the phrase notices of amendments, that's referring to the clerk's package that has been distributed. Am I correct?
Ms. Kwan, can you please repeat?
So pertaining to the amendment that was moved by, that was sent to us, it uses the phrase notices of amendment. So from the premature, actually I'll just read the whole thing so that everybody knows what we're talking about. That the motion be amended by replacing the words current study of with the following: potential breach of privilege resulting from the premature distribution of notices of amendments to. And the phrase notices of amendments, that's referring to the amendment package that's been sent out from the clerk. Am I correct in understanding that?
Yeah. If I can ask Mr. Reddycop to please clarify that what you are saying in your amendment relates to the amendments package, or not, as indicated by Ms. Kwan.
Thank you. Yes, I mean, the short answer is yes. It is when the clerk released the different amendments, we all submitted our amendments to the clerk. The clerk compiled them and submitted them back out to us. That's the point at which the numbers are assigned to them, and they are sequentially put in order. And I believe that's the process where the putting them in order part is related also to the sequence that the amendments fall in the bill itself. Section 1, Section 2, Section 3, etc. So those amendments are put in that order. They're numbered by the clerk, and then they're sent out to those of us on the committee, and that's the point at which they are still confidential, and they're not something that can be shared outside of the members of the committee, and that's what's being referred to by the notices of amendments in that.
Thank you, Mr. Reddycop.
Madam
Ms.
Speaker, if I could
Kwan?
just- Thank you, Madam Chair. If I can just finish then. I'm fine with this amendment as long as we're clear to say that what we're talking about here is the package that the clerk has distributed after each party has submitted their proposed amendments to the clerk for distribution to committee members.
Thank you, Ms. Kwan. Mr. Reddycop?
Yeah, I think that's the idea here, so I think we should be okay with that.
Ms. Rempel Garner?
Yeah, I on this point, like, I think what I want to know, just sort of hearkening back to what our colleague Mr. Kimek had disclosed at the last meeting, was that there were specific numbers that would have been related to the amendments as they were presented. And I think, just to my colleague Ms. Kwan, through you, Chair, I think that's what we're getting at here is, like, you know, somebody doesn't come up with numbers like that with a crystal ball. It came from somewhere, and I think that's what we're trying to get at with this. So.
Seeing no further debate, we will take the vote on the amendment moved by Mr. Reddycop. Mr. Clerk, if you can please take the vote.
Mr. Ali? Yes. Mr. Dhaliwal? Monsieur El Khoury?
For.
Madame Kayabaga? Mr. Maloney?
Yes.
Mr. McGuire?
Yes.
Mr. Reddycop?
Yes.
Ms. Rempel Garner?
Yes.
Mr. Jenis?
Yes.
Mr. Brunel Duceppe?
Oui.
Ms. Kwan?
Yes?
Yeas 11, nays 0.
Thank you, Mr. Clerk. So the amendment has been adopted. So now we have before us the motion moved by Mr. Dhaliwal as amended. Ms. Kwan.
Sorry, Madam Chair. Actually, I think we have to vote on this main motion first, and then I will have a motion to move as well.
Thank you, Ms. Kwan. So now we have the motion moved by Mr. Dhaliwal as amended on the floor. Seeing no debate on that. Okay. Yeah, I will ask the clerk to please read out the motion as amended. Thank you.
Starting in English, that pursuant to Standing Order 1082, the committee invite Randall Emery to appear on the potential breach of privilege resulting from the premature distribution of notices of amendments to Bill S-245, an act to amend the Citizenship Act granting citizenship to certain Canadians. En français, que...
In the next meeting.
By,
Because,
at the next
yes,
meeting.
so,
Thank you.
because we adopted
Yes.
like an amendment before, so can you start again and read the full motion as amended? We have two amendments. Three.
My apologies, missed the previous amendment. So that, pursuant to Standing Order 1082, the committee invite Randall Emery to appear on the potential breach of privilege resulting from the premature distribution of notices of amendments to Bill S-245, an act to amend the Citizenship Act granting citizenship to certain Canadians at the next meeting.
Thank you. So that's the motion as amended. Mr. Brunel Duceppe,
En français, s'il vous plaît.
Could I get that written in French, please?
if you can please read.
Que conformément
That pursuant to Standing Order 1082, the committee invite Randall Emery to appear concerning the potential violation of privilege resulting from the premature distribution of notices of amendments to Bill S-245, an act to amend the Citizenship Act, granting citizenship to certain Canadians, at the next meeting.
Seeing no debate, we will take the vote on the motion as amended. Mr. Clerk, if you can please take the vote.
Mr. Ali? Mr. Dhaliwal?
Yes.
Monsieur Elkouri?
Yes.
Madame Kayabaga? Mr. Maloney?
Yes.
Mr. McGuire?
Yes?
Mr. Redekop?
Yes.
Ms. Rempel-Garner?
Yes.
Mr. Jenis?
Yes.
Monsieur Brunel-Duceppe?
Pour.
Ms. Kwan?
Yes.
Yeas 11, nays 0.
The motion moved by Mr. Dhaliwal and as amended has been adopted. Ms. Kwan.
Thank you, Madam Chair. I think it would be appropriate that all committee members receive a copy of the email that the chair received from MP Kramich from the last meeting pertaining to the issue. As such, I will move a motion for that email to be distributed to all committee members.
Thank you, Ms. Kwan, Mr. Dhaliwal, and then Ms. Rempel-Garner.
Thank you, Madam Chair. Madam Chair, I was just thinking, to get the things moving, I would love to see the members support this and carry on with the bill.
Thank you, Ms. Rempel-Garner.
Just for colleagues in the meantime, including my colleagues, Ms. Kwan, I think my colleague, Mr. Kimek, may have read the email close to the entirety, and I understand wanting to see a copy of it, and I'm supportive of that, but I think he read it in the record at the last meeting, and it would be on our blues for sure. So there is a public record of it as well. So just to make that point. The other point that I would make is just to, again, on behalf of our colleague from Quebec, that this would be distributed in both official languages as well, too. The assumption is that that would happen. Okay. Thank you.
So Ms. Kwan has moved a motion that that should be circulated. So that is for the committee to make a decision. It's we will have a debate and then vote on that. Mr. McGuire.
Thank you, Madam Chair. I guess the only question I have, and my colleague here has alluded to the fact that it may be mainly available already on the Blues. My colleague, Mr. Kimek, I believe, did read a good deal of it, and of course, his request was in the would have been in the Hansard. Is there a ruling that you've had in regards to whether or not it can be distributed if it wasn't formally presented by him in the House? And do you need some time to decide whether or not it can be distributed in the manner that we're talking about? Thank you.
McGuire, for the question you have to the question which you have raised, just to clarify that it cannot be distributed until or unless it is tabled. But now Ms. Kwan has moved a motion that it should be distributed, and if after the vote that motion is adopted, then I will have to get it circulated to the members after getting it translated into French, because the copy the email which I was given by Mr. Kimmich is only in English. It was not in both languages. Ms. Kwan, and then Ms. Rempel-Garner, and then Mr. McGuire. Ms. Kwan.
Yeah, just very quickly, Madam Chair. I know that Mr. Kimmich read part of that email onto the record, to which we do have. However, we don't have it in its entirety. And I think that this whole exercise is premised on that. It'd be useful and helpful for all committee members to receive it. And I would say that in a timely fashion, so that it will become part of the documentations for committee members to review and before the witness appears on Wednesday. Thank you.
Ms. Rempel-Gardner and then Mr. McGuire. Ms. Rempel-Gardner.
So just a very brief question with regard to my colleague, Mr. McGuire's question. Do you require, Chair, you don't require like us to formally table that. You already have a copy. You're good. Procedurally, we're cooking with gas here.
Answer your question. Yes, I have the email by Mr. Kimmich in English language, and if the motion is adopted, then I will have to get it translated into French, and then the clerk can distribute it. That will be if the motion is adopted. Next I have is Mr. McGuire.
Yeah, that's what I was wondering about. That is the proper procedure then to have this motion come forward. I agree with Ms. Kwan. It would be valuable to have that in our hands, particularly before the witness comes at the next, hopefully at the next meeting. As I know my colleague, Ms. Rempel-Garner, had indicated the imperativeness of that, I guess, in her discussions earlier this afternoon, that it not be put off, that it be as soon as we can, like the next meeting, if at all possible. And so I think that that was the reason that I raised this issue in the first place, just was to proper procedures and protocol in regards to it. I have no problem with taking the time to do the proper translation and to get that out to us in such a manner. And I think that we could proceed with that. I just wanted to ask the question as well, Madam Chair, while I have the floor, that I think some of us have other commitments at 5:30. Was it your intention to hold that today at the meeting, or what's the procedure there? Thank you.
We started at 3:45, so we can go on until 5:45.
Move on.
Thank you. Next I have list is Mr. Reddycop.
My question has been answered. Thank you.
Point of order. I think you'd find unanimous consent.
One second. Let Mr. Reddycop finish. Yes, Mr. Reddycop, can.
My question has been answered.
Okay.
So I'm good.
Thank you. Mr. Jenius.
I think you'd find unanimous consent to deem the motion adopted and the meeting adjourned. No?
No.
No.
Unanimous consent. Ms. Kwan has raised her hand. Ms. Kwan.
Sorry, that was to say no.
Okay. So we have the motion moved by Ms. Kwan. Seeing no further debate, we will take the vote. Mr. Jenius.
Madam Chair, could you just clarify how long it would take to translate the email then before its distribution? Like, will it be here in time for?
How long will it take? Yeah, okay, thank you. Just to answer the question which has been raised by Mr. Jenius, it can take from 1 to 2 days, as per the clerk, to get this translated into French. Mr. Jenius.
So your expectation is that it will be distributed before Wednesday's meeting? I guess that's 2 days.
The clerk is saying that it will be 1 to 2 days. Yes. So today is Monday. It cannot be distributed until it is translated. So we will have to wait for the translation before this email is circulated to all the members. Is it clear to everyone?
Yes.
Okay. So we can proceed to taking the vote. Mr. Clerk, if you can please take the vote on the motion moved by Mr. Kwan.
Mr. Ali.
Yes.
Mr. Dhaliwal.
Yes.
Mr. Edkuri.
Pour.
Madame Kayabaga. Mr. Maloney.
Yes.
Mr. McGuire.
Yes.
Mr. Redekop.
Yes.
Ms. Rempel-Garner.
Yes.
Mr. Jenis,
Yes.
Mr. Brunel Duceppe,
Oui.
Ms. Kwan.
Yes.
Yeas 11, nays 0.
Thank you. So the motion moved by Ms. Kwan is adopted, and we will get this translated into French also. And once the translation is done, the document will be circulated to all the members of the committee. Ms. Rempel-Garner.
Thank you. I'd like to move another motion as well, just in the vein of my colleague Ms. Kwan's. I think that there's probably a little bit more of discovery that we need to do as well around this matter. So obviously we will find out, I hope, through testimony and have the opportunity to question this witness on how they came to be in possession of this type of information. But I think part of the privilege here, part of the exercise in making the determination on privilege on behalf of the committee, but also trying to look at potential remedy, because that would be part of a motion as well, I believe, would be to try and find out like what that chain of distribution would be as well. Certainly so that, you know, if censure needs to happen, censure can be issued, but also that we can make sure it doesn't happen again. So I think what I would like to do is I'd like to move that if any member, or that I move that if there exists any correspondence between members or member staff and this individual wherein the motion or the amendments were distributed, that correspondence also be tabled with the committee for consideration as well too. I'm open to suggestions on wording, but the intent here would be that if there was indeed a forwarding of this to somebody, that we give the opportunity for that person to perhaps table that with the committee for consideration, so that we're just not spinning our wheels when this person comes to committee. I hate to be a stickler on this stuff, but again, we are again, like, we're not considering just like a minor amendment to this legislation. Like, to reiterate, what happened was we had this bill at a certain stage. There was a special motion that happened in the House of Commons, debate in the House of Commons to expand the scope of what we would be considering at this committee. And then we have been essentially table dropping very complex, very technical amendments and being forced to look at that on the floor on behalf of, well, I'm looking down the table here, there's probably about 500,000 people that we represent there alone. I'm not sure how many people my colleague, Mr. Brunel. 100,000. 100,000, okay, 600,000. So that's, like, all I'm saying is that I want to know how did this happen? And how is it that I don't have the courtesy of looking at technical amendments when a third party did? I get colleagues may discuss amongst themselves, and that's fine, they have that privilege, but like the red line is we don't send these things to third parties when we're in the middle of the bill review. And I realize my colleague, Ms. Kwan, has said that like there has been matters brought up before, but I don't believe we're in the middle of a bill review at that time. A clause-by-clause consideration of, particularly of amendments that needed a special motion in the House of Commons in order to be introduced at committee. So, again, for those who are watching, like, this is very serious what happened here. And we have to protect procedure, because when we don't have procedure followed, we have questions about the validity of the legislation that follow. So that would be my motion, and I would say, I would also add a date to the end of it as well, Chair, that would say by Wednesday, that those would be tabled by Wednesday.
Ms. Rempel-Garner, if you can please read the text so that the clerk can capture it. He has not been able to get the text of the motion.
I move that should any relevant communications with the insert name of witness for Wednesday here exist, wherein committee members or their staff distributed amendments to this individual, that those communications be tabled with the committee prior to Wednesday's meeting. Thank you.
Quite a few people on the speaking list. Ms. Rempel Garner has moved a motion, and I have Mr. Redekop, then Mr. Brunel Desep, Mr. Dalival, Ms. Kwan, and then Mr. Janis. So go to Mr. Redekop.
Thank you, Madam Chair. I was just going to do what you already suggested, that we get the motion clearly read out. I just want to make sure the clerk has the motion. And okay, so do we need to suspend for a minute and get the motion?
Have you been able to capture what she read? Okay.
Are we agreed to adjourn? Adjourn the meeting? Yeah, sure. Okay, Madam Chair, I bring the motion forward before you suspend the meeting to adjourn the meeting.
So Mr. Dalival has moved a motion to adjourn the meeting? It's an on-debate, huh?
He's on the speaking list, so he had the floor.
Excusez-moi, pourquoi... Madame la
It was
Présidente...
Mr. Redekop finished. He has... Mr. Can we, like, is this like we have to? Is it a point of order or it's a speaking order? Mr. Dalival, you cannot, on a point of order, move the motion to adjourn. So we go to Mr. Brunel Desep.
Je demande qu'on ajourne
I ask that we adjourn the session for today. I think that it's been enough. First of all, to answer my friend Michel, before we do that, I thought that Conservatives were going to be nice to me because I was nice to them. But the way the motion is presented, I don't have it in French. It's not written anywhere. That's one thing. The second thing is that if we start going into all the communications of our staff on of all the members, we can't do that, especially since we decided that we're inviting the witness at the next meeting. Let's listen to him. Let's ask our questions. Let's see what he has to say. And then we might have questions when it comes to communications with our staff. Can we just stop going around this and adjourn the session?
Motion to adjourn the meeting. Is it the will of the committee to adjourn the meeting? Yes. Okay. So the meeting is adjourned.